I'm here with attorney Sujata Gibson at the Staten Island Richmond County Courthouse. We just came out of a hearing in the Decapua case, and this was a hearing about whether the case would be dismissed, first of all, because the city had asked for the case to be dismissed. And then I think there was an expectation by a lot of the people who came out today that there would be arguments, that you would be presenting arguments to make this a class action lawsuit against the city. And I'm going to ask you to explain what this case is about, but the judge or the city asked that those arguments be put off once again to mid-August. And the judge agreed with that. Well, they wanted 60 days, I think. Right. But the judge agreed to adjourn that part of it. But he did dismiss their motion he did not accept their motion to dismiss the case. So the case will continue, and on August 14th, I believe it was, you'll be back in court presenting your argument to make this a class action lawsuit. And can you explain briefly what this class action lawsuit, if it does become that, is about?
Sure. Well, New York City and the Department of Education engaged in widespread religious discrimination in accommodating people or not accommodating people under their COVID vaccine mandate. And that's actually already, you don't have to take my word for it, the Second Circuit Court of Appeals in federal court has already held that those policies were facially discriminatory, meaning the written policy itself called for discrimination against pretty much every religion except for Christian Scientists. So it was just appalling that they adopted those policies and enforced them. And we're here on claims that anybody that applied under those policies is entitled to the same relief of a reinstatement, back pay, and damages, compensatory and other damages for pain and suffering, and all the consequential damages that occurred, such as loss of homes, having to move out of state, and getting ill without health insurance, all of those things that happened as a result. And we're seeking to certify a class of all DOE employees and contractors who applied for religious accommodation under those policies and were effectively denied relief.
Okay, so you'll be back in court for that on the 14th. How do you expect the case to proceed after that?
Well, it's an excellent sign that the judge denied all motions to dismiss. So the respondents had put in, I believe, 6 different reasons for why some or all of the claims had to be dismissed, and the judge denied every single one today. So that was a huge victory. This case is going forward, and I feel confident that class certification should be granted in any event. It meets the most textbook definition of a circumstance in which this is appropriately a class action rather than individual claims of discrimination.
So I think there are a lot of people out there who are maybe not following this issue, who are saying, why is this still going on? The mandates are over, the vaccine mandates are over. Why are cases like this still proceeding? What's the goal?
Well, the answer is twofold. First of all, the mandate may have technically been rescinded, which was kind of, I think, gamesmanship to begin with. They did that on the eve of our oral arguments in the federal claims. Just for the people in the cheat sheets, we have both a federal class action and a state law claims are now in state court, so both are proceeding. But anyway, no teachers that I'm aware of who were denied religious accommodation have been rehired, despite the fact that the mandate was rescinded in February. People's lives are very much still being traumatically impacted by these mandates and by those discriminatory policies. Tenured teachers have lost their homes or are about to lose their homes. People are going hungry. People have had to move out of state. Some have had to be separated from their own children who had to remain here to finish school while they sought work in other states. It's truly traumatic and horrible what has happened to these hardworking educators. And second, this case isn't just about getting them back to teaching here. It's about making sure that they are made whole for all the damage and that this never happens again. New York City and the Department of Education behaved so badly, so outrageously against the law, that they have to be held accountable because they're not listening to the federal courts who said that it's unlawful to second guess people's religion based on somebody else's view. For example, denying Buddhists relief because the Catholic Pope feels differently than they do. They continued to do that. So the only way that they're going to learn, in my opinion, is to have severe financial repercussions of these actions so that this doesn't happen again to anybody else.
We are here at the Staten Island Courthouse, which is also where the Garvey decision was given by Judge Porzio, the same judge that you're before with the
Decapua case.
That decision that was in October of last year, that decision ruled that the mandates, which were still in place then, were unconstitutional under the state constitution, were arbitrary and capricious. You are now working on the appeal because, of course, the city appealed that decision, and you are now working with Chad Lavelia, the attorney who was on the original case. You've teamed up with him to work on the appeal, and I know that the city's appeal is due. Their final, they have to submit their actual appeal, not just the notice, by the 26th of this month.
Right.
So let me ask you about the Garvey case as well, since you're working on that now. How are you expecting that to proceed after the city? Well, they'll presumably submit their appeal by the 26th. What do you expect to happen in Garvey after that?
So the appellate courts unfortunately move rather slowly in most circumstances. They have this sort of they've exhausted their extensions as of right. They've really asked for several of those. But now they're going to have to perfect their appeal, it's called, and give real briefing and arguments about why they think they should succeed. We'll then have 30 days to answer those papers. Oral argument will be scheduled at some point after that. We're going to be asking for expedited argument, and then the court will take however long it takes to make a decision. For reference, in the Kane v. de Blasio case, we had oral arguments in the Second Circuit Court of Appeals back on February 8th of this year, and we still don't have a decision in that case. So it can take many months sometimes, but we are committed to seeing this through. I was brought on with Children's Health Defense. I'm working through them on the Garvey case and on this one as well. And they have committed to backing these suits, and I've committed to being in these suits for as long as it takes to make sure that justice is served.
Why are they backing the Garvey case? Why is that case important?
It's important because it holds that none of the mandates were constitutional to begin with. And I think one of the things that we saw during COVID that really was ramped up was this sort of new rulemaking through administrative agency instead of through lawfully elected representatives. And that kind of rule by administrative fiat is so dangerous to all of us, especially in this public health context, where you have unelected bureaucrats that can somehow just eviscerate and take away all of your most basic constitutional rights and freedoms without any due process or any second guessing. And so Garvey really puts the brakes on that and says that this was not a constitutional exercise in administrative regulation. This was lawmaking, and that's improper for an administrative body to do.
All right. So I will see you back here presumably on August 14th for the next hearing in the Decapua case to hear you argue for that becoming a class action. Is there any final things that you want to say to people out there who are following this issue?
Hang tight. We know that you're suffering, and we are praying with you, and we're working with you, and we're not going to stop fighting for you.
All right, thank you. Thanks for talking with me.
Thanks.